2 to 1. All right, now let's go to the trailer bills on page 7. Let's do
I'd like to recommend going with the State Water Board's comments on striking disadvantaged community, make it open. This is the revolving loan program that's been amazingly successful.
Yeah, and very valuable. I'm sorry, public comment? Oh, didn't I call for public comment already? Are you standing up for public comment on, all right, come forward. I thought I had called for it.
Mark Fenstermaker on behalf of the Sonoma County Water Agency. Just echo the point that Senator Pavley just made. We would support striking that language and opening up to all communities. Thank you.
Hey, good morning, Chair. Thank you. Sorry, slow on the draw there. Just on the refuge water provisions, we really appreciate the committee's work on this, as well as the department and the agency, and agree with the point that Director Bonham made that the funding more appropriately comes from the pot going to the Department of Fish and Wildlife rather than the statewide obligation. But thank you for everyone's work on that, and we support the $10 million for that purpose. Thank you.
All right, thank you. Welcome.
Juan Altamirano with Audubon, California. We just want to echo our colleagues' point from TNC to make sure that we extend that gratitude for the $10 million for the refuges, but you want to make sure that that's allocated properly.
Okay, thank you. Welcome.
Madam Chair, Richard Harris on behalf of the Water Reuse Association. We want to recognize Mr. Howard's remarks regarding the revolving fund. Of course, that's very, very important to getting the recycled water projects built, and we would associate ourselves with their recommendation. Thank you.
All right, welcome.
Casey Elliott on behalf of Orange County Water District, again wanting to echo the comments on the revolving fund, making those projects eligible for all communities. Thank you.
Thank you. Welcome.
Pilar Añate Quintana here on behalf of the North Bay Water Reuse Authority, and just seconding the comments of water reuse. We really believe that the loans and grants together represent a really good integrated approach to maximizing funding, and so we second those comments.
All right. Welcome.
Madam Chair and members, Mike Dillon representing the California Association of Sanitation Agencies as well as County Sanitation Districts of Los Angeles, echoing the previous comments. Thank you.
Madam Chair and members, Beth Olaso on behalf of West Basin Municipal Water District and Inland Empire Utilities Agency, echoing the previous comments on the revolving loan funds.
All right, thank you. All right, so we have a motion, do we not?
So move with the understanding that we're striking the disadvantaged communities, and this is for items 1, 2, and 3.
No, just let's do item 1
Item
separately.
1 by itself. All right, may I ask one question? What was the action, Mr. Howard, of the Assembly on this, or have they taken budget sub 3? Have they?
Oh, okay, fine. All right, then we will do 1, 2, and 3 together, but yes, the question.
No action, thank you.
No action. All right. All right, we can do all of them together.
All of them together. And I'll amend my motion to include items 1, 2, and 3 with the striking of the word disadvantaged, opening up to all communities, revolving loan funds for the purpose of matching and Prop 1.
All right, please call the roll.
Senator Wolf?
Aye.
Senator Nielsen? Aye. Senator Pavley?
Aye.
3-0, those 3 items are approved. Now, we have an addendum to the budget. Before we get to the Central Valley Flood Protection Board, there are drought-related trailer bills that are recommended in the May revision that we want to go through. And who's going to take the lead on that? Okay, come on down. Yes. Okay, these are all part of the drought-related, the drought proposal. So why don't we start with the Drought Expanded Local Enforcement Authority.
Thank you, Senator Wolk. Michael Lawfer, Chief Counsel with the State Water Resources Control Board. And as we work through these trailer bills, I will try to do it in the order in which they were posted. The Sergeant-at-Arms is circulating a document that summarizes the administration's trailer bills. This had been provided earlier this week to committee staff. and was heard yesterday in the Assembly Sub-3. Before I begin specifically addressing the expanded local enforcement authority trailer bill, I did want to provide a little bit of context. No doubt the committee has heard extensively, and Senator Nielsen alluded to it a little while ago, about the devastating effects of this drought. And both at the administrative level as well as the legislature, there has been a robust and dynamic response to this drought. You and your colleagues have passed 2 rounds of emergency drought legislation, and in the most recent signing ceremony, the governor, joined by legislative leaders, acknowledged that we would all need to continue to be vigilant for other efforts to identify legislative fixes that would result in immediate drought relief to expand local potable water supplies, as well as to improve California's drought resilience. Collectively, the trailer bills do just that. They allow the state to expedite the disbursement of funds available as a result of Proposition 1. They expedite projects that in the short and long term can promote drought-proof local water supplies. And they enhance local authority to implement local conservation ordinances and statewide conservation efforts that will extend potable water supplies. And finally, they improve the reporting frequency and quality of diversion data so the state can more effectively implement the water rights priority system. The first trailer bill, Trailer Bill 820, is designed to address expanded local enforcement authority for drought conservation ordinances. California's local water agencies have a diverse range of authorities to enforce their local conservation measures. Some local agencies under existing law have enforcement authority, but others do not. Last year's drought legislation made violations of emergency drought regulations adopted by the State Water Resources Control Board subject to infractions of $500 per day. But not all local agencies could initiate the proceedings necessary to utilize this new drought enforcement authority. This proposal would provide a minimum set of enforcement tools to allow local water agencies, including wholesalers, retailers, and non-urban water agencies. The tools would allow those local water agencies to enforce their own water conservation ordinances, as well as the emergency conservation regulations adopted by the State Water Resources Control Board. Penalties assessed under this new authority would be directed to local conservation programs. I can provide additional detail, but if there are questions on this specific one, I'm happy to address it first.
All right. Are there questions from the committee? Yes, Senator Nielsen.
Well, these are sweeping powers, and indeed there need to be an awful lot of questions asked. And I'll take us back a year, the drought legislation of last year. And this legislation, in part, allowed the governor a lot broader authority and latitude to declare a drought emergency. It was not ever made clear that whatever is imposed during this emergency, are those impositions extinguished at the end of the drought? I think that's an important point that needs to be cleared up, and it has not been thus far. In that legislation, the board has been empowered to do some pretty substantial enforcement and in place regulations, but yet be exempted from the administrative law process. That concerns me. These penalties are up to $10,000 for the first violation. If there are subsequent violations, it looks like it's a penalty of an additional up to $10,000. Is that accurate?
That is correct, although that for the first 30 days of violation, it would only be one $10,000 penalty. If the individual continues to violate after that, they would be subject to an additional up to $10,000 and then $500 per day after that. Again, those are maximum, and there are various factors identified in the trailer bill that would have to be considered by a court or by the local agency if it chooses to administer the penalty.
Yeah, I understand nature and persistent extensive harm. It also says any corrective action taken by the violator. Would corrective action having been taken by the violator by virtue of the regulation then reduce the penalty? If they've taken corrective action, would that automatically reduce the penalty?
It would be one of the factors the local agency or a court would have to consider, and that would mitigate against the penalty amount.
Okay, in this section, I see later where there's, in addition to all of this, there can be civil penalties.
The penalties that we're describing, the $10,000, is a civil penalty. The issue is it can be imposed either administratively, following a process that comports with due process. Many local agencies already have those kind of processes in place. Or it could be imposed judicially. And some local agencies may choose not to set up an administrative process and could go to court. The penalties could not be stacked. You could not do both an administrative civil penalty and a judicial penalty.
Okay, is this 10,000 per incident? For example, of a point source diversion, would it be 10,000 for each point source diversion?
I want to be, and just for clarity's sake, Senator, diversion is something that we use in the water rights context. This is limited to the conservation regulations that either a local community would have or implementation of emergency conservation regulations that the board had adopted. And so it would be per violation. And a good example would be a local agency ordinance that prohibits filling ornamental lakes with potable water. Filling that lake with potable water, or whatever the local ordinance that's being violated, that would be a single violation that would be subject to the various factors and then ultimately a penalty of up to $10,000.
Well, it would appear to me, though, that you say not stacking, but by multiplying multiple violations on a person, a property, or an authority, you in effect are stacking 10,000, 10,000, 10,000, are you not?
Well, if they're different violations of different ordinances, then that would, for example, if the community had an ordinance that said you can only water 2 days a week, and here are the days, and then also had an ordinance that you can't hose down your driveway, those are different ordinances, different violations of them could result in multiple penalties. But you wouldn't, consistent with constitutional principles, you wouldn't have multiple violations, or a single violation result in multiple penalties.
As far as then, if you go to court, then there are court due process requirements. What are the due process requirements of the board? Does the accused have a right to confront the accuser and have a thorough hearing and present evidence?
So the U.S. Supreme Court has issued a number of decisions over the years identifying, and essentially there's a test that they do. It's a multi-part test for what type of proceeding the administrative agency would have to have. Keep in mind, this is only about local agencies, not about the State Water Board. And the way that I read those precedents and what's known as the Matthews v. Eldridge balancing test, because this results in a deprivation of property if the penalty is assessed.
And diminution of property value, too.
I think I suppose there would be circumstances where that could come into play. I think the most important issue is initially there would be a deprivation of property associated with a penalty. And the court has held that those require hearings. The evidence needs to be presented. Whether or not there needs to be cross-examination of percipient witnesses may be an open issue, but the court has extensive precedent on the type of proceeding, and it would have to be a hearing process, presentation, know the charges against you, an opportunity to rebut them, present evidence, and then ultimately an unbiased decision maker. And then, of course, the trailer bill legislation provides that ultimately whatever decision the administrative agency penalty it imposes would be subject to review by a court.
Would the adjudicative authority be an ALJ that's in the employ of the board, or would it be an outside ALJ or arbitrator?
And again, just to be clear, if you're referring to a board, it would be a local agency, because this is the local agency power. There is no magic formulation. The courts have not required that it be an independent ALJ. They have said that the ALJ's compensation, for example, cannot be tied to the penalties. There's a seminal California Supreme Court case from the last 10 years involving San Bernardino County that held that. But it has to be an unbiased decision maker. It doesn't necessarily need to be an independent administrative law judge.
Well, it sure sounds to me like this could be set up where the agency becomes the investigator, the prosecutor, and the adjudicator all in one, and the appellate court. That sounds like pretty sweeping powers to me. How can you convince me otherwise?
Well, this isn't a particularly radical notion. I mean, including local administrative agencies, often have those, what we refer to as unitary powers.
Up to $10,000 fines per incident?
Yes, sir. And the key is the courts are concerned. The issues you have are extremely legitimate, and the courts are very concerned about them. The Constitution compels that people have due process, and so the courts have set up a number of markers to ensure that the investigative arm is separated from the adjudicative arm in the agency, that the ultimate adjudicator is unbiased and neutral, and then ultimately that there is an avenue for judicial review. And those features are required by constitutional law, and the avenue for judicial review is explicitly spelled out within the trailer bill language.
It would be in the trailer bill, correct?
It is in the trailer bill that there is an avenue for judicial review, and the constitutional principles are something that flow from the Constitution.
Well, this is probably beyond your control, but I'm going to rhetorically ask, but rather require a response from somebody. How long are we going to have to review the language of the trailer bill before we vote, so I could determine what this due process is? That's really, really important.
So the trailer bill language was posted on the Department of Finance's website.
It's on there now? Okay. All right. Well, we'll review that at that time. Now, the local agencies, are they gleefully embracing this? Are they excited to have this new authority and power? They're being given pretty sweeping police powers. Are they happy to have that?
So I will say that the genesis of this particular trailer bill language was discussions with local agencies, and the governor announced it at a meeting with representatives and mayors from across the state of California. And in Assembly Sub 3, there was testimony from water agencies in support of it. I personally have been in communications, although I don't want to speak, I'm sure there's an Aqua representative here, with representatives of Aqua who support this concept.
Okay. Well, this does really concern me very much. Now, the empowerment of police authorities to local agencies, who will be their water police? Will these be, my concern is who's going to be the staff person? Will they be required to know anything about water law? Or is this just going to be somebody that's given a piece of paper and this is what you're looking for and go find it?
So for clarity's sake, I think it's, again, very important that these are about enforcing the conservation ordinances that the locality adopts under Water Code Section 375. This is not about California water law, pre-14 appropriative rights, and riparian rights. This is much more a traditional code enforcement type activity. And so the legislation, as it's posted up on Finance's website, allows the agencies to essentially designate a code enforcement officer consistent with processes. I believe it's in the government code, or it could even be down in the, it's in the penal code. And it's for a code enforcement officer. And what they're enforcing are their local ordinances or the water board's emergency drought conservation requirements, not our water rights emergency drought.
I understand the difference between water rights, but my connection here is the enormous power and consequence affected by this now empowered officer to do 10,000 per incident. That's racking up a lot of the dollars, and that's a pretty awesome burden for just somebody that's been working for a local agency, and now they're sent out to enforce this, to be the water police for the state of California, and really for the state of California. The local authority is just being empowered by the state to do the state's work, I would argue.
Certainly, but keep in mind these local code enforcement officers are out to identify violations, and it's ultimately either the court or the adjudicative body that the local agency establishes that will actually determine whether the violation occurred and then consider the various factors identified in the trailer bill language, the nature and extent, the duration, the gravity, and the corrective action to determine what the appropriate penalty is. These code enforcement officers would not be setting the actual penalty amounts.
This proposal, empowerment, That is for the purpose of the declared emergency action of the governor. Is that correct? That's what initiated all of this.
That is what has initiated it. However, the trailer bill language would allow local agencies to enforce their conservation ordinances, even because these ordinances exist outside of a drought. Okay. And the one thing we have learned is, California needs to move into a culture of conservation. What we're seeing these past 4 years, there's more of it to come. And the more that we can conserve in years of plenty are important for helping us get through these drought times. And so while the board's regulations would not be able to be enforced outside of a drought because they disappear after the drought emergency, the local conservation ordinances could still be enforced.
And I would say, sir, that alarms me almost as much. I will just have to say that I hope the people of California are listening, understanding the consequences that they are going to be subjected to if this becomes a force and fact of law. So I'm very, very wary of this, sir. Thank you for your answers, though.
Did you want to continue then with the next, which is drought, unless you want to say, drought penalties, I believe is the next, 823?
Trailer Bill 823 concerns drought penalties that are assessed by the State Water Resources Control Board for violations of the emergency drought conservation regulations that it adopts. Currently, under existing law, penalties assessed by the State Water Board or a court for violations of the State Water Board's emergency drought regulations are deposited into the Water Rights Fund. They are commingled with other deposits into the Water Rights Fund and subject to appropriation by the legislature for the authorized fund uses. In the Water Rights Fund, what these penalties presently do is they essentially increase the fund balance and potentially reduce the need for increases in fees in subsequent years. This proposal would require the State Water Resources Control Board to separately account for those penalties assessed for that it or a court assesses for violation of emergency conservation regulations. Those funds would then be available for appropriation by the legislature for conservation activities and programs.
All right. Any questions on that? How about moving to drought monitoring and reporting, 824?
Trailer Bill 824 would currently, under existing law, most surface water diversions in California are required to be reported to the State Water Board on either an annual or 3-year cycle, depending on the type of water right. There are not uniform standards for measuring diversions, and although persons typically have to be able to describe the amount of water diverted in a specific month, there is a wide range of techniques and mechanisms by which the individuals determine the amount of water they diverted during the month. The lack of timely and accurate water diversion data has frustrated California's ability to respond to the drought and enforce the water rights seniority system. This proposal would establish a baseline of annual diversion reporting to the State Water Board for all classes of water rights and specify minimum measuring accuracy for diversions in excess of 10 acre-feet per year. The State Water Board could provide exemptions to the measuring requirements based on certain factors, including feasibility and unreasonable expense. The proposal would provide authority for the State Water Board to develop the measurement device regulations as emergency regulations, not subject to the California Environmental Quality Act, and would generally allow the State Water Board to adopt regulations to further the reporting requirements. The permanent regulations adopted by the State Water Board could be enforced using civil liability authority, extending some but only a portion of the State Water Board's emergency drought authority from Senate Bill 104, enacted last year by the Budget Committee, and it would allow them to apply outside of a drought. That would only be with respect to the regulations, enforcement of the regulations, and it would only be with respect to the $500 per day violation authority. You may recall that the legislature last year enabled significantly enhanced penalties during a drought of up to $10,000 per day for a violation of a cease and desist order, and several $1,000s for unauthorized, and the value of the water as well, for unauthorized diversions during times of drought. Those penalty authorities would not be extended outside of a time of drought. It's only this ability to enforce regulations and the $500 per day penalties associated with those.
All right. Unless there are further comments, let's move on to 825. Oh, sure. Senator Nielsen.
Well, sir, a while ago, or a moment ago, you said that the board's powers would extinguish at the end of the emergency. 824 now says extending some state water boards emergency drought authority to apply outside of a drought. So this is a permanent situation.
So to be clear, the board already has regulation authority outside of a drought. The wrinkle is that many of the board's regulations cannot be enforced outside of time of drought, except to the extent that they are incorporated into a permit or license. And so it's that enforcement capability, and only one piece of the board's drought enforcement capability, that would be extended outside of times of drought.
Well, you know, again, I find that egregious and unreasonable. Why would the board adopt a regulation and not subject to CEQA?
Well, simply put, what you have seen this past year is the board and water right holders working very closely to try to enforce the water rights priority system in California, but simply there being a dearth of data. And so there has been efforts by our board staff working closely with water diverters in the Delta, on the San Joaquin, and along the Sacramento to try to get that information. Simply put, we need to be able to have the information in a more timely way. And if we want to have regulations that provide, for example, the exceptions that I mentioned for cost and feasibility in place so that we can manage this drought as it continues and likely continues into next year, then the board needs to be able to move expeditiously.
Please repeat then what, quote, stakeholders have been involved in the developing of this legislation. What stakeholders?
I'm not referring to the legislation. I'm referring to the
regulations. You're talking about being inclusive. I sounded like now who?
Well, I'm talking about how we have struggled this past year and a half since the drought state of emergency was declared in January 2014 to get a handle, and we've worked closely with water right holders. Northern California Water Association has been terrific in terms of trying.
Well, Aqua is not what I'd consider the prime authority in this area, but be that as it may, have they talked with you, or Aqua, have those people been involved? Farm Bureau?
On the trailer bill language itself?
Mm-hmm.
No, sir.
No. Okay, well, I'll hope that they're going to get involved, you know, as this trailer bill gets introduced, and I hope not in the dark of night with only moments to review it. But that said, the what would, again, the exemption for CEQA, is that just because you don't want to take the time to go through a process of CEQA? Everybody else has to go through CEQA. Why shouldn't an agency? This has got CEQA implications.
Well, the primary issue is simply the need to act promptly and to start getting this information. I mean, what we have seen is poor quality data and data that's not available in a timely way. And so if we want to be able to get that information in a timely way and be able to enter next year and be prepared for next year's irrigation season to enforce the water rights priority system, we need to be able to have data that's accurate and timely, and that's the purpose of this particular.
I think accurate data is, you know, a valuable goal. But I don't know if so at the expense, you know, of the public, that there are great consequences. It's going to affect the citizens of California, and they're not going to have any say or very little say in this, and that's a great concern to me.
There will still be a public process if this trailer bill were enacted into law, Senator Nielsen. I mean, that is one of the benefits of the board system is our board members can't act outside of a public process.
Well, how would that be the case if the board is exempted by the legislation year before last from the Office of Administrative Law review process? Where's that going to come then?
Well, the way that it comes, I mean, first of all, our board and Chair Marcus has been terrific in this regard, along with her colleagues. I mean, if you look at, for example, the emergency conservation regulations that the board adopted in a very accelerated process, went through 4 iterations of public documents and comment over the course of a 1-month period. I mean, our board is committed to public meetings, accountability, and transparency. And while the trailer bill language allows the board to go through an expedited Administrative Procedures Act process, there will be a public process with substantial comment, no doubt, and probably workshops as well as subsequently a meeting for the board to consider any regulations to implement the trailer bill.
There will be explicitly defined as such in the trailer bill, sir. Is that right?
Well, our board, it is not defined in the trailer bill at present, but our board always conducts workshops on significant items before they take it to action by the board. And I have no doubt in this regard that we would go through at least a multi-meeting cycle in order to.
But that's not to your determination. It's whoever writes the trailer bill will make that determination, correct?
Well, also for clarity, this is one of the trailer bills. The entire package of trailer bills I'm going through was posted up on Monday. The trailer bill does not say anything about the board's process other than it can use the expedited process. I'm just relating what our board's process is and our commitment of our board members to go through a full public process in order to get these types of activities done.
Yeah, okay. Well, you know, put me down as a little bit skeptical, about this, the openness. I know how this legislative process has often worked lately. Not always, but sometimes. So the draft language that's up on the website now, that'll be the final language that the legislature is going to be voting on?
Well, the recommendation out of Assembly Sub 3, which will be up for vote only later today, is to hold this to conference.
Okay, so we'll define whatever is in conference committee. We will write the trailer bill in conference. Is that what I'm led to believe?
Well, the administration has posted its trailer bill language. Obviously, what the legislature chooses to do, as you are well aware, I mean, this is ultimately a legislative act.
Well, let me wryly smile. This is a slithery eel. And it's an eel that's dangerous. It has a bite. And we are well advised to be very careful how we proceed. I'm going to have some more questions, Madam Chair, but I'll cease for now.